One person is dead. The defendant caused that death. But which crime have they committed? The answer could be murder, it could be manslaughter, it could be something else entirely, and it all turns on intent, context, and whether any defense applies. This is the map of homicide. Homicide is not a single offense. It is a family of criminal offenses sharing one common feature. The defendant's act or omission caused the death of a human being. Let's work through each branch in turn, starting with the most serious and moving outward. Murder sits at the top of the homicide hierarchy. It is the most serious offense in English criminal law and carries a mandatory life sentence. The classic definition comes from the 17th century judge Sir Edward Coke. Murder is the unlawful killing of a reasonable person in being under the king's peace with malice aforethought. That phrase, malice aforethought, is the mens rea, and it means either an intention to kill or an intention to cause grievous bodily harm. The GBH limb is crucial. The defendant does not need to intend death at all. If they intended to cause really serious harm and death resulted, they are guilty of murder. This was confirmed in R. Voy Vickers, 1957, and R. Vol Cunningham, 1982. The actus reus requires that the victim is a human being, a fetus in utero is not covered, and the killing must be unlawful, so lawful killing in self-defense is excluded. There is no longer any year-and-a-day rule. That was abolished by the law reform, Year-and-a-Day Rule, Act 1996. The mandatory life sentence means the judge has no discretion on the sentence itself, only on the minimum term. Voluntary manslaughter is a peculiar category. The defendant has all the elements of murder, the unlawful killing, and the intention to kill or cause GBH, but they successfully raise a partial defense that reduces the conviction from murder to manslaughter. It is not an acquittal, it is a reduction. There are 3 partial defenses under the Coroners and Justice Act 2009 and the Homicide Act 1957. First, loss of control under sections 54 and 55 of the 2009 Act. The defendant lost self-control due to a qualifying trigger, either a fear of serious violence from the victim or circumstances of an extremely grave character that caused a justifiable sense of being seriously wronged, and a person of the defendant's sex and age with a normal degree of tolerance might have reacted the same way. Loss of control replaced the old provocation defense and critically does not require a sudden loss. There can be a delay. Second, diminished responsibility under Section 2 of the Homicide Act 1957 as amended by the 2009 Act. The defendant suffered an abnormality of mental functioning arising from a recognized medical condition that substantially impaired their responsibility for the killing. This is a medical defense. Juries hear psychiatric evidence. Third, suicide pact. The defendant kills in pursuance of a settled agreement between themselves and the victim that both will die. The surviving party is guilty of voluntary manslaughter, not murder. Involuntary manslaughter covers killings where there is no intent to kill or cause GBH. The defendant lacks murder mens rea entirely. This is where fault is assessed objectively or constructively. There are 2 main forms. The first is unlawful act manslaughter, also called constructive manslaughter. The defendant commits an unlawful act, a crime, which is objectively dangerous in that a sober and reasonable person would recognize it carries the risk of some harm to another person, and that act causes death. There is no requirement that the defendant foresaw death or even serious harm. It is enough that the reasonable person would have foreseen some physical harm. This was established in R.V. Church, 1966, and confirmed in R.V. DPP Volv Newbury and Jones, 1977. The unlawful act must be a criminal act. A civil wrong is not enough. R.V. Franklin, 1883. The second form is gross negligence manslaughter, which comes from R.V. Adomarco, 1995. The defendant owes a duty of care to the victim, assessed using civil negligence principles. They breach that duty, and the breach causes death. The key question for the jury is whether the defendant's conduct was so bad that it should be judged criminal. This is a circular test, confirmed as compatible with the ECHR in R v Misra and Srivastava, 2004. It is the form most commonly used against professionals, doctors, employers who cause death through catastrophic failures of care. Infanticide is a narrow statutory offence under the Infanticide Act 1938. It applies only where a mother causes the death of her own child who is under 12 months old, and at the time of the killing, the balance of her mind was disturbed by reason of her not having fully recovered from the effect of giving birth, or by reason of the effect of lactation. It operates both as a standalone offence and as a partial defence to murder, reducing what would otherwise be murder to a verdict of infanticide. Sentencing is treated as equivalent to manslaughter, so the mandatory life sentence does not apply. The offence reflects a historical recognition that postnatal mental disturbance may fundamentally impair a mother's responsibility. It is a very rarely prosecuted offence, and in practice, courts tend to deal with such cases sympathetically, often with non-custodial outcomes. Alongside the common law offences, Parliament has created a set of statutory driving offences where the defendant's manner of driving causes death. These sit in the Road Traffic Act 1988. The most serious is causing death by dangerous driving under Section 1, which carries up to 14 years imprisonment, raised to life imprisonment by the Police, Crime, Sentencing and Courts Act 2022. Dangerous driving means driving far below the standard of a competent and careful driver, and it would be obvious to a competent driver that driving that way was dangerous. There is also causing death by careless or inconsiderate driving under Section 2B, and causing death by driving while unfit through drink or drugs under Section 3A. These offences are important because gross negligence manslaughter is technically available in driving cases, but prosecutors generally prefer the statutory offences as they are easier to establish and have more predictable sentencing guidelines. Here is your check for understanding. Dev punches Ola in a rage after she provoked him. Ola falls, hits her head, and dies. Dev intended to cause GBH. The four options are A. Involuntary manslaughter because there was no intent to kill. B. Murder because intent to cause GBH satisfies malice aforethought, though loss of control may then reduce it. C. Infanticide because the stress disturbed his mind. D. Causing death by dangerous driving because the punch was dangerous. The answer is B. Intent to cause GBH is enough for the mens rea of murder. Dev did not need to intend death. Involuntary manslaughter is wrong because he had intent. The jury would then separately consider whether the partial defense of loss of control could reduce murder to voluntary manslaughter. Homicide is a family of offences. Murder demands intent to kill or cause GBH and carries a mandatory life sentence. Voluntary manslaughter has that same intent, but a partial defense reduces it. Involuntary manslaughter involves no intent to kill, either an objectively dangerous unlawful act or gross negligence. Infanticide and the statutory driving offences cover specific fact patterns with their own rules. Every homicide analysis begins with murder and works outward from there. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.